Good morning, everyone. My name is Colin MacDonald, and I am here today to explain the primary legal concept for our upcoming mock trial, cybersquatting. So, broadly speaking, cybersquatting is the act of purchasing one or more domains that either contain a trademark, a trademarked phrase, a famous person's name, or something along those lines, with the intent to later sell those domains back to the rightful owner at a profit. In order to prevent this, in 1999, the Anti-Cybersquatting Consumer Protection Act, or ACPA, was enacted and passed to help discourage cybersquatting and also help those who are victims of cybersquatting have some legal avenues to take to get back those infringing domains. There are three main forms of cybersquatting. The first is namejacking. With namejacking, an individual purchases a domain which includes a famous person's name or a famous trademarked phrase before the rightful owner does. This person then tries to sell the purchased domain back to its rightful owner, often with a large profit. The second form of cybersquatting is known as typosquatting. With this, someone purchases a confusingly similar domain name, such as apple.com but with three P's instead of two, and then they try to sell that purchased domain back to its rightful owner, often threatening to sell it for high prices to a competing company if they don't comply. The last form of cybersquatting is expiration-focused cybersquatting. With this type of cybersquatting, an individual purchases recently expired domains and then targets the previous owners of these domains, threatening to auction off these domains if they don't purchase them.
Hello, my name is Richard Pang, and I'm here to discuss the first legal element, which is the qualifications for protection under the ACPA. In order for a mark to be protected by the ACPA, there are certain factors that must be considered. The first factor is the distinctiveness of the mark. A mark's distinctive nature mainly involves how unique the mark is compared to other marks. The second factor is how famous the mark is at the time. Famous marks could involve a famous quote that is derived from a movie or celebrity or something similar. It should be noted that personal legal names can also be protected should they qualify under the first two factors. What both of these factors ultimately come down to is whether or not a mark in question can be registered as a trademark. Trademarks are meant to protect the distinctiveness of names and identifications, and are thus protected by the ACPA. However, if a mark cannot qualify itself as a trademark, it is therefore not liable for protection under the ACPA. Ultimately, the measure of how distinctive a mark can be seems rather subjective. However, the case of B&J Enters versus Giordano provides a good precedent for how trademarks should be measured for distinctiveness. Generic marks typically cannot qualify as a trademark unless it has earned a secondary meaning in the eyes of the public. What this means is that a trademark has worked in a way that it is intended to, by allowing the public to identify the mark to the business. It is the duty of the plaintiff to prove this secondary meaning exists through multiple factors. These factors could include the advertising expenditures, consumer studies linking the mark to the source, plaintiff records of sales, unsolicited media coverage of the plaintiff's business, attempts to plagiarize the mark, and the length and exclusivity of the plaintiff's use of the mark. All of these factors should be taken into account when deciding whether a mark qualifies as a trademark that can be protected under the ACPA. One more thing that should be considered is trademark dilution. Should a mark over time lose its original intended meaning of linking a mark to its source and thereby losing its secondary meaning in the eyes of the public, it would also in turn lose its protection under the ACPA. A good example of acquiring a secondary meaning in the eyes of the public would be the company Apple. While the term Apple is certainly a generic term that applies to the fruit, Apple as a technology-based company has proved that its trademark on the term Apple in the technology industry has acquired a second meaning in the eyes of the public. They have the market records, the product sales, and several customer studies that have already been conducted to back this claim. When one talks about Apple when it comes to technology, pretty much everyone can attribute the generic word to Apple's products, meaning that the trademark works.
Hello, my name is Hector Luna, and I will be presenting the legal element of bad faith intent. The ACPA provides the court with 9 bad faith factors to consider. Since they are rather long and a little complicated to understand from first glance, I will give you an overview of each factor. The first factor focuses on the defendant's intellectual property rights of their name. Timing is also extremely important when it comes to this factor. For example, if a company named Paramount Landscaping registers Paramount.com before Paramount Pictures registers it, then this could be seen as good faith, since Paramount Landscaping has a trademark right to their own name, and they are not using it to direct unwarranted traffic to its site that would have otherwise gone to Paramount Pictures. But let's say someone secures a domain name before securing the intellectual property rights of their name, then this will be considered bad faith since the holder of the domain name did not have an interest in the name to begin with. The second factor finds that if the defendant registered a domain name involving his or her legal name, then it should be considered good faith. The exception to this factor is if the defendant used a nickname as opposed to a legal name. The third factor is similar to factor 1 in that timing is important. If the defendant has previously used a domain name for commercial purposes in the past, then good faith can be established, even if the defendant does not have a trademark in the name. However, if the defendant changed the content of the website in order to profit from a well-known mark, then bad faith can be found. The fourth factor involves fair use. This factor protects websites that use domain names similar to popular trademarks for the purpose of criticisms, parodies, or commenting. If the court finds that the contents of the domain name have commercial purposes, the domain name cannot be confused with good faith and will be considered to have violated the ACPA. The fifth factor protects websites from those seeking to redirect traffic to another revenue-generating site. If there is evidence that the intent of a domain name was to confuse the users to a revenue-generating site in which the user was not expecting, then it will be considered a clear violation. The sixth factor is considered the stereotypical cybersquatter. This factor is when a defendant registers a domain name featuring a trademark and then they try to sell the trademark to the mark owner in bad faith. The seventh factor allows courts to view evidence of a person who has registered multiple domain names using different combination of names, addresses, and contact information as bad faith. This factor was put in place because cybersquatters typically lie to the domain name registers so that they cannot be found. The eighth factor mentioned addresses a distinctive feature of cybersquatting known as warehousing. This is when cybersquatters obtain multiple domain names, each slightly different variations of a famous mark, without regard to the goods and services of the owners of the mark. It is important to note that it is only considered bad faith if the domain names are using a variation of a famous mark. If, for example, someone registered hundreds of domain names made up of common first names, even though it might resemble a trademark name, it would not constitute as bad faith. The ninth factor mentioned is directly related to the strength of the mark. This factor states that the stronger the mark, the more likely the defendant knew of the mark and therefore acted out in bad faith. The stronger the mark, the more deserving the mark owner is of the protection of the ACPA. It should be noted that the reverse is also true. The weaker the mark, the more likely it is that the defendant did not know of the mark and therefore did not act out in bad faith. Another important fact to mention is that the courts are not limited to the 9 factors listed above when they are making a determination if the defendant had acted with bad faith intent to profit. Bad faith intent to profit is a lot more simple to explain than the 9 factors of bad faith intent. The reason being is because bad faith intent to profit boils down to one simple concept. When someone registers a domain name that is identical or confusingly similar to that of a famous or distinctive mark for the sole purpose of profiting, they have violated the ACPA. I will now talk to you about cases relevant to legal element 2. 2 relevant cases for legal element 2 are Venetian Casino Resort LLC versus VenetianGold.com and Virtual Works Inc. versus Volkswagen of America. In the case of Venetian Casino Resort LLC versus VenetianGold.com, the plaintiff sued the defendant alleging that the defendant's domain names were confusingly similar to that of the plaintiff's own mark and were registered with bad faith intent to profit. The plaintiff did business as the Venetian Casino Resort and had various registered trademarks. and the defendant used multiple domain names that contained a combination of the words Venetian, gold, and casino. All domain names used by the defendant were used to offer casino-type gaming services. The court eventually held that the domain names held by the defendant violated the ACPA since the owner's marks were distinctive, the domain names were confusingly similar to the marks, and the registrants of the domain name had a bad faith intent to profit from the owner's mark. Additionally, according to the ACPA, the factors violated were 5, 8, and 9. Factor 5 was violated because VenetianGold.com and other domain names were registered by the defendant were confusingly similar and were used to redirect users to a revenue-generating site that the user was not searching for. Factor 8 was violated because the defendant warehoused multiple domain names that were slightly different of a famous mark, and Factor 9 was violated because the defendant used a mark that was well known. In VirtualWorks Inc. versus Volkswagen of America, the plaintiffs registered a domain name knowing that some of their users might think that the domain name was confusingly similar to that of the defendants. The plaintiffs decided to use the domain name for their own businesses and sell it to the defendants for money if the opportunity arose. When the defendant contacted the plaintiff regarding the name, the defendant threatened to sell it to the highest bidder if the defendant did not buy the rights. The court eventually ordered that the plaintiffs must relinquish the rights to the name and that the plaintiffs had violated the ACPA by acting with a bad faith intent to profit from a protected mark to which the domain name was confusingly similar. I will now pass over the mic to Jake Sanchez, and he will walk you through legal element 3.
Hello everyone, my name is Jake Sanchez. I'll be going over legal element 3 on our law of cybersquatting. This one will involve fair use. Alright, so fair use is going to deal with how the defendant is going to be using our trademark and whether we determine if that falls outside our realm of fair use or not. Alright, so now let's take a look at how fair use is applicable to our case and how it deals with cybersquatting to determine whether or not it is actually going to be considered fair use. Alright, so first aspect I want to go over was using a generalized versus a distinguishable mark in your domain name. So on the left you can see Apple. Once again, it's a well-recognized mark that many people know. So they just go under the name Apple, which is a very general term, which is why I want to introduce the example of someone maybe going under the name Smith's Apple Farms, who is actually just harvesting and distributing, apples like the fruits, which is very different from the market that Apple, the technical company, is in. But they have the similar, term Apple under their trademarks, which allows them to kind of use that generalized Apple term to be able to go after like a domain name such as like www.apples.com or Apple or, Apple misspelled, something like that. Very general and can't really be attributed to a case for cyber squatting, as it's just generalized and anybody can get it as long as they deal with apples and their own trademark. This is very different from a distinguishable mark such as something like George Mason University, which is not general at all. Alright, so if the mark is considered to be distinguishable, then we need to see if the domain name is considered to be confusingly similar to that of the mark. This is important because this could be used in conjunction with something like bad faith intent. If somebody's using a confusingly similar mark under bad faith, then that would be considered cyber squatting, as long as the mark is protected under the ACPA. So the case we wanted to cite was VirtualWorks Inc. versus Volkswagen of America. So in this case, you can see that the appellants, which was VirtualWorks, they used a domain name that was confusingly similar to Volkswagen's, who were the appellees in the case. And you can see that from the case it was done on purpose. VirtualWorks was trying to profit from this domain name, so obviously being using a bad faith intent along with having a confusingly similar domain name would consider them to be found for cyber squatting. However, people are free to use a name that is pretty similar to that of the mark owner, as long as they're doing something like criticizing the owner or making a parody out of whatever they do. They could make a domain name that is very similar, as long as all they do is just bash on the owner of that mark, then they would be fine. They're not trying to profit or do anything that would be considered bad faith intent, like selling the domain or anything like that. So the case that's cited is Lampareo versus Falwell. And basically, this is where a minister, somebody made a domain name that had the minister's name in it, but they just doubled one of the letters. But they used the site only to create a forum for people just to criticize his ideals, rather than try to hurt his business or profit from it in any way. It was just a place for people to kind of share their opinion and their negative opinions towards that minister. But this was considered fair use and was perfectly fine since all they were doing was just criticizing. On the flip side, misleading users would not be okay and not something you'd want to be found for as the defendant. This would be very bad and would kind of coincide with the bad faith intent aspects. As you can see that they were trying to just use a confusingly similar name as to that of a mark owner, but they were trying to lead the users away. This would not be considered fair use. Criticizing is fine, but kind of redirecting and preventing those users from getting to their end destination would not be okay at all. They're kind of just trying to pretend to be the mark owner and just leading them away, or just confusing the users instead of actually showing that they're completely separate and trying not to do something like harming the business of the owner.
As we conclude this presentation on cybersquatting and the legal elements that make up a case for cybersquatting, I would like to quickly summarize what the ACPA intends to do and what it does not intend to do. The ACPA is there to help legitimate people and companies by preventing them from having to pay large sums of money for domains they legally should have the rights to. It also criminalizes cybersquatting, which can help discourage it. But the ACPA is not designed to limit the First Amendment rights of individuals. People can still buy as many domains as they want as long as they plan to use them and they're not intentionally trying to maliciously profit from purchasing these domains. Thank you for listening to our presentation. Do you have any questions?